Yes, counsel. Good morning.
Good morning, Your Honor, and members of the court. Gary Brackett, representing the appellants, College Hill Realty and et al. With respect to this appeal from the appeals court decision, Your Honor, regarding the interpretation of Chapter 140, Section 22, as it relates to lodging houses in the Commonwealth. The appeals court decision affirmed a housing court decision which determined that no more than 3 unrelated individuals could live in a dwelling unit pursuant to the housing court's interpretation of the lodging house statute.
3 unrelated, I'm trying to understand this. Individuals who are unrelated to whom? To each other or to the person who, the landlord?
Well, Your Honor, the provisions of Chapter 140, Section 22 make a specific reference with respect to lodgings let to 4 or more people not within the second degree of kinship to the operator, of the lodging house.
Right. So however, oh, God, I'm sorry. Go ahead. Continue.
However, the housing court decision didn't even use the particular language of the lodging house statute in making its determination. The housing court simply said that there could be no more than 3 unrelated individuals living in a dwelling unit.
And where does that come from?
Well, Your Honor, I think that actually comes from a provision of the Worcester zoning ordinance that relates to a completely separate issue of enforcement.
That's what I thought.
And which, for whatever reason, rather than dealing with the lodging house statute as we argued before the court, did not apply to tenants in a dwelling unit in this situation. The housing court chose to address whether or not the 4 tenants exceeded the definition of family under the Worcester zoning ordinance without referencing the zoning ordinance in its decision.
Let me ask you that about the zoning ordinance in Bonaventura. I could find no subsequent history after the appeals court sent it back. Are your clients, the landlords, did they now, as a matter of zoning ordinance, I don't know what the status of Worcester is, but do they now have to comply with the zoning ordinance about lodging houses?
Well, Your Honor, the issue with respect to...
I know that's not our issue. I understand that. I'm just trying to figure out what the relationship is between the two.
The Worcester zoning ordinance, which was an issue with respect to the Bonaventura decision, but we argue is not an issue here since this is a lodging house statute.
I understand that. I just as a factual matter, what kind of part of Worcester are these apartments in? Is it zoned for lodging houses? That's my question.
In this particular section, lodging houses would be allowed by special permit in certain sections of the city. So there is a provision under the table of use regulations that addresses lodging houses and requires special permit before the planning board.
That would be another consequence if we say this is a lodging house.
That's correct, Your Honor, because one of the underlying problems with the Worcester zoning ordinance, which we include within our reply memorandum, is the fact that the zoning ordinance makes reference to the same language in the lodging house statute, which blurs the distinction between a lodging house and a dwelling unit. That language is whether or not the unit, a dwelling, is rented to more than 3 individuals who are not within the second degree of kinship to the operator, which then raises a question once again, in its extreme situation, here we have 4 college students renting a dwelling unit with a 1-year lease. The dwelling unit has 4 bedrooms. And in each of these units are contained within multifamily homes. So are they
like apartment buildings or like a 3-family home, something like that?
2- and 3-family homes, Your Honor, of the 5 properties that are in question. So this raises what we believe to be, and we argue, is a rather absurd result of where you could have 3 individuals on the first floor of a 2-family home, 4 individuals on the second floor. The second floor, under this interpretation, would be deemed to be a lodging house. The second floor would require sprinklers. The first would not. The second floor would require an on-site manager. The second floor would require the whole listing that we have in our reply memorandum of the requirements under Chapter 140. And we don't believe that that's what the courts of the Commonwealth have determined in the past in distinguishing between a tenant and a lodger.
So just let me play the devil's advocate here. If somebody who's running a lodging house signs a lease with 30 people that are crammed into a huge open space because they have a lease, is that now okay?
Well, Your Honor, the question, I think, relates to the definition of lodgings, which the appeals court did not address in the case under appeal, which we believe has been addressed in cases in the Commonwealth going back to White versus Maynard in 1892, which actually predated the 1918 adoption of the lodging house statute, and in Hall versus Edgartown as well, making a distinction between a lodger and a tenant. We argue that the tenants in this case have access to the full dwelling unit, and under the state building code, the dwelling unit contains facilities for living, sleeping, cooking, and bathing, whereas a typical lodging unit, as detailed in the summary that we provided in the Vo versus Boston case, the historical summary that the U.S. District Court did in that decision, a lodging unit is really just sleeping accommodations. It may or may not have access to cooking facilities, but generally there may be a shared bath on the floor or things of that sort. So, Your Honor, we're answering your question. Even if there is a lease between the operator and the lodgers, the question we would argue is, what is the status of those lodgings? Is it a single room that's leased for a period of time?
Can I ask, go ahead. Did you finish that thought? It's just going back to Justice Bonsford's question and coming at it from a different direction. Let's assume we agree with you that this is not a lodging house under the state statute. So what happens next in the city of Worcester?
Well, Your Honor, for the court's information, the city has first approached this particular issue trying to seek zoning enforcement. There are actually 7 properties that are under appeal that I'm handling with respect to the zoning enforcement actions, cases that have been consolidated in the Housing Court of Worcester by Chief Justice for Administration Mulligan. Those cases are awaiting hearing. And frankly, Your Honor, I think—
This relate to that? Will our decision here have any bearing on that?
Well, from the point of view for my clients, Your Honor, our position is that the city pursued injunctive relief under the lodging house statute, having attempted to seek enforcement from zoning. We're challenging the provision of the zoning ordinance in those actions. So while that's not in the record of this case, I think it's important for the court to know that. The city then changed its enforcement pursuit to bring this action under the lodging house statute. And we argued that these particular units did not qualify as lodging houses under the cases we've cited, including the most recent appeals court case of mass sober housing. That case clearly distinguished. There were 10 adult males within this particular program living in a residence, each of whom had a relationship with the landlord, each of whom had access to individual rooms. We believe that fact situation is much different than the fact situation presented here.
Let us assume that you prevail in persuading us that this is not a lodging house. What do we do with regard to the contempt?
Well, Your Honor, our position is, and we've argued, that the court may set aside the finding of contempt in this circumstance if it finds that the underlying injunction was, in fact, invalid and that the court erred as a matter of law. These were students living in homes, as I indicated, 2- and 3-family homes, during the academic year. Attempts were made to relocate them, and there was a request. A motion for stay was made to the housing court, requesting that the students be allowed to reside through May 25th, which was the end of the academic year. In fact, students had to be relocated as a result of the original contempt finding, Your Honor, prior to the commencement of their exam period. And our position was to the court that the court was in error in granting the injunction sought by the city because of the arguments we've made in our briefing this morning, that these were dwelling units, not lodging units. But, Your Honor, we would request that the court set aside the finding of contempt and set aside the imposition of the $17,000 in fines that were awarded by the housing court.
Was there an appeal to a single justice of the appeals court to dissolve the injunction?
There was a motion for stay which was denied, Your Honor.
A motion for stay in the trial court?
In the trial court and also the appeals court. Okay. And on that point, Your Honor, we believe that a careful review of the case law that we've provided, as we've indicated, the Maynard versus White decision predates to 1892. Makes a clear distinction between a lodger who does not have a property interest in a piece of property versus a tenant who does.
Can I just, I'm sorry, just to finish this question about the contempt. So this was, the housing court decision was in whenever it was, and I appreciate what you say about your clients and not and having the problem relocating. The next year, case is still pending, right? I mean, I forget what year this all happened.
Yes, Your Honor, in 2009. And in fact,
2009, okay, so here we are. So my question is, between 2009 and today, have your clients been complying with the Worcester Housing Court's and the Appeals Court's interpretation of this?
Yes, yes, Your Honor.
So they have not rented to 4 or more students?
They have not. And the hearing on the contempt orders was held on April 26th. I'm sorry, the contempt orders were issued on April 26th, following a hearing on April 1st.
Yeah.
And during the course of the hearing, we also requested the housing court judge that if there was to be, that the court would stay any decision until such time as we were able to relocate one of the tenants in each of the 5 units.
Was there any, as a further follow-up, was there any resistance on the part of any of the students to being relocated?
There was, Your Honor, because of the fact that they were living with friends. They had been living there during, many of the students in question were seniors, had been living with friends for an extended period of time, and of course during that 08 to 09 academic year.
Did you try to evict any of them?
We actually tried to seek cooperation, Your Honor. We were working with, if you can imagine, we were
Yeah.
receiving calls from parents, both in-state and out-of-state, trying to determine what was happening with respect to the students' living situation. We were trying to accommodate them. We were trying to arrange to provide alternative living situations, but in some cases, the housing court judge was actually arguing that we should, if necessary, place them in a hotel, which we thought was a rather extreme remedy under the circumstances. That if there was to be, in fact, a resolution to the matter, that it could wait until May 25th during the expiration of the term of the exams.
So this background information was presented to the trial court and to the appeals court?
Yes, it was, Your Honor. And in fact, the information presented to the housing court was the fact, as I indicated earlier, that the city had shifted its enforcement position from, rather than seeking enforcement under the zoning ordinance, and all those cases had been appealed under 48 Section 17 to the zoning board, and then from there to the Superior Court or Land Court. They were consolidated at the request of the parties. Those provide for a de novo hearing under 48 Section 17. The housing court judge was advised of the fact that those appeals were all pending, and the issue of the validity of the zoning ordinance was in question, in addition to the arguments we made to the housing court judge and the appeals court judge, that these clearly were not lodging houses pursuant to the interpretation of the case law of the Commonwealth. Under Chapter 4, Section 6, the procedure for interpretation of the statute is what the clear and unambiguous interpretation would be of the distinction between a lodging unit and a dwelling unit. One of the arguments we made to the appeals court, which, for my sake, Your Honor, I didn't understand why it was rejected, the state's entire regulatory scheme, the state building code, the fire prevention regulations, the state sanitary code, the room use occupancy tax required by Department of Revenue, all make clear distinctions between dwelling units and lodging houses or lodging rooms, the definition of a lodger versus a tenant. The appeals court chose to essentially to suggest that that was not relevant. We made the argument that the U.S. District Court, in issuing the decision in Vaux versus Boston, had done a very careful analysis and determined that a lodger has no property interest, whereas a tenant has a clear property interest. That particular analysis was rejected, even though that analysis had been incorporated within the appeals court decision in the mass sober housing case. It appeared as if the appeals court, and we certainly respect the concern of the appeals court in this case, was more concerned about the policy question of the protection of individuals from so-called adverse conditions, which the city argues in its brief is a major issue. We believe that all of those interests are protected by the regulatory scheme that I just described, the sanitary code, the fire code, the building code.
Is there there is no requirement to have sprinklers, I take it?
There would be no requirement within a dwelling unit, but in a lodging house, all of the...
I understand that, but I mean, if the city's interest was in sprinklers, let's just say that's what it was very concerned about, could they get there some other way?
Well, the provisions of Chapter 148, 26H, which govern the sprinkler system at the present time would not apply, and it would either be by way of a special act of the legislature or an exercise of home rule authority by the city to try to extend sprinklers to a dwelling unit which contains fewer than 4 individuals,
right,
which we would suggest would be, obviously would create a difficult expense not only for the property owners in the city, whether they may be owner-occupied multifamily dwellings or individuals who hold these properties for investment purposes. So in closing, Your Honor, We'd respectfully request that the court reverse the appeals court and the housing court. And because of the importance of this, we request that the court address and define the term lodgings as it should be applied and interpreted under Chapter 140, Section 22. We also request that the court reverse the order of contempt issued by the housing court and rescind the award of fines to the city. While we understand the fines were to go into a fund which is to provide for housing enforcement, things of that sort, we don't believe that our clients are responsible for those fines because we believe that the housing court decision and the appeals court decision are based on errors of law. Thank you, Your Honor.
Good morning. May it please the court, my name is Ann Ruffolo, and I represent the city of Worcester.
Do you really expect us to conclude that an apartment rented to 4 students is a lodging house?
Yes, Your Honor.
Do you really?
Yes, Your Honor.
And that's because they are unrelated to the landlord?
Well, there aren't any facts in this particular case to establish whether or not, well, what the facts are is that no one is related to anyone.
And why does that matter? I mean, the statute says where lodgings are lodgings, keyword, are let to 4 or more persons, essentially not related to the owner.
To the conductor.
To the conductor.
The person conducting the lodging house, yes,
Conducting
which
the lodging
encompasses.
house. So you would say that would be the landlord.
In this case, it's possible that a landlord could rent a dwelling to one individual who would then sublet that unit to other people. So it encompasses both
So if it's a
possibilities.
family of 5, unrelated to the landlord, who rents an apartment, that's a lodging house?
Well, it's then there's the case law that talks about living together as a family unit,
What case
which would
law?
then
Not
Related to
not
this
part of
statute?
this.
Related to this statute? The definition of lodging house for state regulatory purposes?
no, they're right, correct, Your Honor.
So it would apply. It would apply to just what Justice Cordy says, right? Your
It
definition?
would, but then we have the case of Bonaventura, which does specifically state that a dwelling unit can be a lodging house. And specifically in Worcester, a dwelling unit can be a lodging house, which does allow.
So is it just up to what your enforcement department chooses to feel is a lodging house? I mean, if what you say, if Justice Cordy is correct, every apartment that is rented to software engineers who are not related to the owner of the apartment, if there's 4 or more, could be charged with being a lodging house, correct?
That's correct, Your Honor. The fundamental purpose of this statute is the protection of individuals and the protection of groups. The statute was established in 1918 during World War I, when the legislature was very concerned with substandard health and safety issues in lodging houses.
In lodging houses?
Yes, Your Honor.
Houses where rooms are rented?
But it doesn't say rooms, Your Honor.
Lodgings. What is a lodging?
So, Your Honor, a lodging, actually in the case of...
That rooms for let in a house or apartment which someone else is the primary occupant?
That's
Rooms for let.
That's a dictionary definition, Your Honor. In addition to that, the case of Salvetti, which is quoted in both of the briefs, actually puts lodgers and tenants together in the same group when it comes to licensing purposes.
Well, does it strike you as strange that, as Mr. Brackett says, that all these other regulatory provisions, the building code, the fire code, et cetera, make a very large distinction between lodging that clearly do not treat dwelling units and lodging houses very differently?
I would agree with that, but, Your Honor, then I would direct the court to the plain meaning of the statute. If you look right in the next clause after this statute defines what a lodging house is, it is to include fraternity houses.
Yes.
What we
But
have...
you rent rooms in a fraternity house.
Yes.
I know, I've rented rooms in a fraternity house.
I mean, every room isn't a dwelling unit.
But from the perspective of ensuring safety for various groups, specifically for various groups of people who are not necessarily related to each other, the component that is most important here is a sprinkler system. And I would ask if did the legislature only intend to provide sprinkler systems for occupants of single-family or single-room-only dwellings, or did the legislature perhaps intend to to provide protections for young people who are on their own for the first time, which is what the Vo case actually says.
Young people, but this has nothing to do with young people. It could be
Statute
old
is,
people, it could be software engineers, they could be professionals, they could be any number of people that have agreed to rent an apartment together.
Well, that's what we're dealing with in the factual pattern here, Your Honor.
So I want to make sure I understand this. A lodging house, if a landlord rented a house to a family of 7, mother, father, 2 mothers, 2 fathers, whatever, and 5 kids, that would be a lodging house if there was no relation between the landlord and any member of that family.
I would agree with the court. There is no statutory, or there is no case law interpreting that part of the statute.
You would say your definition would include that, would it not?
The definition of the statute would include that. That's correct.
And by that same definition, if there were a family of 3 and then there is a new baby, that house becomes transformed with the addition of the 4th occupant into a lodging house.
It would. It is not enforced in the city of Worcester like that.
But that, we can't decide it because of what you choose to enforce, correct?
Correct, Your Honor. But the language of the statute is clear and unambiguous. And I would argue to the court that there is no absurd result reached. If there are 4 or more unrelated people occupying a single family home,
Unrelated to whom?
the statute says to the person conducting the lodging house, which could either be the landlord or a sublessor. That unit is a dwelling, is a lodging house and requires a license. The same thing can be said of a dwelling unit in a 2 or 3 family house, which is rented to 4 or more unrelated people, and the same thing can be said of one apartment in a 40-unit apartment building. If it's rented to 4 or more unrelated people, that unit is a dwelling, is a lodging house.
And this legislation was passed in, what, 1918?
Yes, Your Honor.
Any suggestion that it was meant to apply to a routine home where there are 4 people renting from somebody else?
The stated purpose of the statute is to protect young people on their own for the first time without family support.
Which is a funny way to describe a family.
The stated
doesn't that-
purpose of the statute, in the statute, it says
in the Vo
our
decision-
purpose is to
In the Vo decision, or the Vo memorandum, which there is a pretty good statutory history analysis, that is what the court found was one of the purposes of the statute.
And we have said another purpose was because these lodging houses often had, I forget the term, but were houses of ill repute, or houses where immorality went rampant, not consistent with the description of a typical family home.
No, Your Honor, but it can be said of these houses, which are rented to many college students. There is.
So this is focused on the sexual immorality of college students. If there were 4 people who were 65 years old and living together, it would be different?
Your Honor, it goes back to whether people are looking out for each other, perhaps in the situation of a fire. I think that's why some of the cases make the distinction between families and unrelated people. I think there's a natural inclination of a family to help each other out in a fire situation.
You don't think that, well, I won't go there, but do you, never mind.
If I can turn to the issue of the contempt, is it your view that even if you were not to prevail, we should still uphold the contempt sanctions?
Yes, Your Honor. There is some good language in the appendix, in which the landlords admit that they did nothing for a period of 2 or 3 weeks to attempt to comply with the court's order. I think the orders of contempt were issued because there was a direct defiance of the housing court's orders. I do think those should stand.
Doesn't the, is it Commonwealth versus 707 Main Street offer authority for not imposing the contempt if we were to agree with Mr. Brackett's position on the meaning of the statute?
It may.
Why isn't our case law, why shouldn't we rely on our case law, Hall versus the Zoning Board of Appeals of Edgartown, and say that, look, if there's a lease that creates a property interest, it is not a lodging house? Why isn't that a sensible way to resolve this?
Well, I think the appeals court stated that it is sometimes difficult to discern between lodgers and tenants, but that the safety of the occupants shouldn't turn on that distinction.
Does the,
So if the landlord rents to his son or daughter who happens to have, 3 or 4 kids, enough to get it up to 4, the landlord renting to his or her daughter has tenants and not lodgers. But if the landlord rents to somebody else with 3 or 4 kids, there's a safety issue. Somebody
That's
not related
if the
to him.
landlord rented to people who were not related to the landlord, yes.
And the safety is of the unrelated tenants somehow is more at risk than the landlord's kindred.
I believe that is the notion.
Does that make sense?
I think it does. I think in a
Is that because the landlord's always going to be there if a fire starts, or?
what if the
well,
landlord lives
in Worcester,
California?
there's a requirement of an on-site property manager to obtain a lodging house license. So that person would be required to get.
But in Justice Spina's example, if you're renting to your, does niece fit within the second degree?
Niece would be within the second degree.
So you rent to your niece in Worcester, but you've actually moved to California. So her safety and the safety of her 7 children doesn't matter, but if I rent to somebody who isn't related to me and I still live in California, then it does?
That is how the statute is worded.
Is there any evidence, I think the appeals court says this is not, they don't form a single unit. I mean, it's sort of as a factual matter. These 4 people don't have a family, like a combined dwelling unit. Was there any evidence about that, that they don't share meals, that they don't share, they don't eat together? Anything about how they live?
There was absolutely no evidence as to how they live. The counsel for the landlords made proffers. There were no leases admitted into evidence.
Okay, so that statement by the appeals court isn't a factual one, is that right?
I would tend to argue that there weren't facts. One of the landlords did testify, but I don't believe he testified as to what the makeup of the living situation was.
But is it clear that what they leased was not merely their personal room, but the entire premise?
No.
Those facts were not in evidence that
Wasn't the assumption that nobody was disputing that there was a lease for the entire apartment that the 4 of them shared? Right?
That's correct, Your Honor.
So there's no suggestion that they didn't share the kitchen, share everything else, right?
That's correct, Your Honor.
And each of the occupants signed a lease, is that right?
We don't have that information. It was just a proffer that there is a lease. So I would ask that the court look carefully at the Bonaventura case because I think it very specifically states that a dwelling unit can be a lodging house. And in the end, both the landlords and the amicus urge this court to restrict the meaning of the statute to only apply to single-room occupancy dwellings. The statute absolutely does not say that. The statute is broad and...
Depends what lodgings mean, doesn't it? It all depends on what lodgings mean. If lodgings means the rental of a room, then that's what it means. And if the rental is not for a room, but for an apartment with all the facilities of an apartment, then maybe it's not a lodging.
Lodging is not a defined term in the statute, neither is house, and neither is let. Those are undefined terms in the statute. So I would urge the court to uphold the decisions of the appeals court and the housing court. Thank you very much.
Thank you, counsel.